I paid $1 million. It's a case of 2015 million. Till today, 13 years, petition is now custody million. So I pray this matter may be taken up in the next.
What is the offense?
Yeah.
Offense?
Offense 376.
2013 he is in custody.
Right.
He should-
15 years.
It is on Tuesday. Tuesday. Okay. Tuesday, huh? Ready himself.
Item 7.
File them. Yes.
And after the appellant something last day committed the evidence of the DW2. So in that the deceased wife is supposed to take in the house of the parental house. To start this special also directed to me to give the reply whether the deceased date has been occurred in the maternal home or parental home. So that aspect I will address before the summons form now.
Yes.
Now I am basically PW obviously this is your PW3 also that definitely your
PW3.
yes sir.
Okay. Yes, PW3, huh?
PW2 other place.
Yes. Days?
Digital case also 46.
46. Yes.
This is fully my marriage with the accused from whom point was
Read the relevant part.
yes sir. The relevant page.
PW6 is not 46.
Correct.
1 minute. Not 40.
15 days prior to marriage.
1 minute, 1 minute. I am just searching that. PW2. PW2 is Raghunath Swami.
PW2 is other. There is Raghunath.
Hmm? No, 1 minute here. Position of prosecution. PW2 is Minoketan. 74. Page 74. Minoketan 74. Yes. Yes.
Yes. Also the 9.
Para 9. Yes.
Person used to visit Pune at the maternal home during which she known that she was assaulted by her husband and father-in-law and mother-in-law. Its balance dowry amount was paid 2 months after Pune was sent to maternal home. 10th, that is handwritten. After Aswan given died there, kindly answer. Then under normal circumstances.
Para 9.
Person.
Rosananda used to visit Kuni at the matrimonial during which he told him that she was being assaulted by the father-in-law. Balance of the amount is not 2 months of. Where are you reading? I don't understand. PW2, I am there. PW2. Para 9 is. Are you holding the same brief? Pavitra Swami. Then Para 9. Yes. Para 9 starts with Rosananda used to visit.
That's it.
Yes.
That
Where is the handwriting thing?
This is the second line in this paragraph. Maternal home, there is mentioned that you also kindly answer only. Then after Aswan given by Narana, she died there, otherwise then under the other
Read the full paragraph.
Yes. Prasananda used to visit Pune at the maternal home during which she told him that she was being assaulted by her husband and father-in-law and mother-in-law. His balance dowry amount was not paid. 2 months after, Purni was sent to matrimonial home, that particular thing that is mentioned there. After assurance given by Narama, she died there, otherwise then not circumstances. Then that to to support, I am reading PW PW5, who is the IU also clearly stated that I have implemented the father of the decision also. That is PW5 also.
PW5. Yes.
I was posted that particular also.
PW 5 years. Which para?
Paragraph 19 also.
Read it. Yes, read it. My investigation reveals that he was brought dead to the hospital by her husband along with Pitambar Mahanti. Yes. Yes.
Yes, sir. Paragraph 4.
Yes.
That's my paragraph 14 also.
Yes.
Death is was occurred in the house of the matrimonial home of the deceased family.
You have said the same sentence thrice.
Yes.
Show me the evidence.
Yes, and come to the particular paragraph also.
Now you will keep on searching, then
So that particular paragraph 19.
you give written note. I can't. I heard it earlier also. Is it judgment is your offer? Written note to be submitted by the council. You give written note along with the part of the evidence which you are relying upon. The only thing you have to show me that the deceased has died in her house or in the matrimonial house. If she has died there in her house, then you can't put the presumptive sections into service to bring 304B. If then the 304B goes. 304B goes and 498A only remains. Because 304B has been convicted on the basis of the presumption. There are evidences which suggest that the death has occurred there in the house of the deceased. What are the evidences you have shown, Mr. Naik?
Your Lordship.
Death occurred there in the house. What are the evidence?
Sir, the evidence that I had given was section 313, where at page number 53.
I
and
know. House of.
Where he was asked regarding the death of Kuni, where the accused replied.
First one is.
First one.
First one is.
Sir.
You don't read it. Tell me orally. I have pointed out already. Yes.
Yes, sir.
First one is 313 statement.
Yes, sir. 313, where he was asked about the death, where he said Kuni. Next is that, sir, deposition number 1, the independent witness, DW1 at page 93.
DW1.
Yes, sir.
Next.
And sir, the next is officer in charge who corroborates that he saw the independent witness and the husband in the hospital with the body.
IO evidence para?
Sir, the last paragraph.
PW5.
PW5, sir.
5. Para 19.
Yes, sir.
Para 19. Yes.
That completes my circumstance.
Yes, I got it. Yes. Give written note. Specific question I asked. You are now searching those things.
PW3 is the brother, interested witness.
Read it.
Yes, police informed us in our village about death of Kuni and took me to article in police records. It clearly mentioned my father was absent from home when police came and gave information about death of Kuni. अगर पापा भाई को जान पे देख रहा हूँ कौन है कि police informed. That part clearly speaks that death is.
But the period undergone.
My lord, period undergone.
You find it or to give it.
I'll
period undergone. Like this question. Yes. Yes. Next.
Item 11.
Period undergone. You have to tell.
My lord, I will. Obliged.
Yes.
Yes, my lord. The present appellant was placed under trial for offences under 498, 304B, 302, along with 4 others. And all the accused persons have been acquitted. But present appellant, who is 84 years old at present, he has.
No. How it is listed then?
It was in the list.
Huh? No, if it was just 19, how it is listed today?
93.
I am wondering if it is the proceeding is there, it is adjourned to 19, and how it is listed today? Yesterday, what by mistake? The proceeding is a by mistake, and listing is also by mistake. Everything by mistake.
93.
See on 5th. Which proceeding you are showing this one? And this is the proceeding 5-8. Huh? Then it is listed for 19.
Let it be on 19 ballot. It is nothing. I have been asked also before.
If you are ready, I can hear it. I have no problem.
Only ballot 4 DP Act conviction. And appellant is the father-in-law. Sentence is 1 year and fine to pay a fine. 84 years old. Husband has been released, other in-laws have been acquitted, everybody has been acquitted. This man, he is the father-in-law. And he was 55 during that relevant period. At present, he is 84.
96 appeal.
84 years old. আমি 20-25 দিন খন্ডে নাই 28 দিন খন্ডে আছে
ଇଏ କରୁଥିଲେ।
ନାଇଁ ତାହା ବି 4 of DP Act ରେ ବି ମ୍ୟାଟେରିଆଲ ନାହିଁ ଯୋଉଟା କି disbelieve କରିଛନ୍ତି with regards to 498
Just grant probation and finish it up unnecessary. Why unnecessary?
Vale.
84-year-old man. Why?
That is enough. That will be sufficient for him.
Huh.
It is deathbed, man. That is his son.
See, he is 84. Now we can't send him to jail.
4 of probation of offense.
Probation of offense.
Another case, my lord, was pleased to adjourn it to the last item, where my lord was pleased to ask whether any of them are government servant or not. In one case, 354, 323.
Hmm.
Appellant number 3 is a grammar rakhi.
Hmm?
Grammar rakhi.
Grammar of is not government.
Apparently, PO Act, that was the opinion,
Huh.
but directed me to obtain instruction from the lawyer whether he is government.
Anybody is going to
The
be
grammar
affected.
rakhi in
Grammar of
that will not be a problem for this one. Last item.
Item number?
97.
Huh?
97.
97. That will be pure liquid. It will be the evidence of pure water. Huh? Pure water. It have 19 is missed and it is pure water. 90 pure water. लिख के रखो इसको दे दो
Item 16.
May I please, your lordship?
अंदर ज्योति फाइल yes
Lordship, I can speak on submission. Let's do that in a moment.
yes yes yes
Lordship. In this matter, the accused are convicted under 20B of NDPS Act,
what is the recovery
recovery of 73 kg of ganja and 8 kg of ganja powder, your lordship.
73 kg of
73 kg of ganja
huh?
and 8 kg of ganja powder, your lordship.
8 kg
8 kg.
powder huh?
Yes, your lordship. Your lordship, the judgment dated on 6/9/96.
What is the sentence? 4 years.
Sentence of 4 years and
Fine of
minimum
5,000 rupees.
8,000, your lordship.
Then your case is discrepancy in timing of the search and seizure
Your lordship.
and fail to prove the guilt of convicts beyond all reasonable right.
Yes, your lordship.
General
And
thing.
last is non-compliance of the statutory. provisions.
Non-compliance of statutory provision 42, 50 and 57,
55, your lordship.
55, sorry,
55. your lordship.
55. These are the cases.
Yes, your
Okay,
lordship.
first, let us come to first. Discrepancy in timing and search. Which evidence?
Case in nutshell is on 27/7/1994, PW9. Lordship, there are total 9 witnesses, prosecution witnesses. Out of 9 witnesses, the PW9 is a SI of exercise.
Come to PW9, which part?
PW9,
Hmm,
page
47,
47, your lordship.
yes. What does he say?
No. Your lordship, let me just tell you the prosecution case in nutshell. On 27/7/1994, PW9 was under this patrolling duty among his staff and received some information regarding accused number 1 and accused number 2 that they were selling ganja from their home. Getting after the receive of this information, they directly headed towards the village
Yes.
from that's just a
1 PM they got the information.
sorry,
and
pardon your
1
lordship.
PM they got the
1
information.
PM,
and
they got the information, your lordship. I'm coming to that, your lordship. 1 PM, they got the information. And according to the prosecution story, your lordship, PW7, who happens to be the executive magistrate, the then executive magistrate, was with them. But your lordship, if you see, come to page number 44, your lordship, of the deposition. 44.
44.
Yes, your lordship.
PW7.
Yes, your lordship.
Yes.
PW7, the executive magistrate.
Yes. What is it?
Point number 2, your lordship.
Yes.
I got the order on 26/7/94 to accompany the APR force. We left Hon'Ble early in the morning at about 4:30 AM. The raid was conducted about 5:30 AM and the raid was completed at about 8 AM.
Yes.
Kindly mark this point, your lordship.
5:30 to 8 AM.
5:30 to 8 AM, your lordship.
Yes.
But according to the prosecution story, that they got the information at 1 PM and the raid started at 1:30, your lordship. That shall be taken into consideration, your lordship.
140.
1:30.
Yes.
30, your
Mm.
lordship. The first
Yes.
point.
Yes.
Now coming to the second ground, your lordship. Coming to the second.
So you are saying that the timing is mismatching from.
Yes, your lordship. The time is completely mismatching. According to PW9, who is the SI of excise, he said that he was along with the executive magistrate, who was along with the APR forces, and the raid was conducted in front of him. But your lordship, according to the prosecution in the statement, the executive magistrate was not there at the town, and he started at around 4:30. And he said that the raid was conducted at about 5:30 AM and completed at 8 AM in the morning, your lordship. Now coming to the second point, your lordship.
Then you are saying that the executive magistrate could not have been present there
No.
at the time of the
At
raid.
the time of
which
the
is-
raid, your
yeah.
lordship, if the raid has been conducted at 1:30 PM, then the executive magistrate was not present. So the raid was conducted in the absence of the executive
Yes.
magistrate, your lordship.
Yes. Next point.
Next point, your lordship, if you see out of 9 witnesses,
Mhm.
out of 9 witnesses, your lordship, first 2 witnesses were the Caesar witnesses,
Yes.
but they did not supported the case, your lordship.
PW1 and 2.
1 and 2, your lordship, they did not supported the cases.
Seizure.
And PW.
This is a story in all NDPS case. Independent witnesses never support. The conviction is only on the basis of the official witness.
Yes, your lordship.
Story in all cases. Yes.
So PW1 and PW2 are the Caesar witnesses who did not supported the.
They were turned hostile. Yes.
They turned
Next,
hostile.
yes.
And also PW8 turned hostile, your lordship. Also independent.
All independent witnesses turned hostile.
Turned. Now, total.
8 was examined for what? Seizure.
Alleged to be a Caesar witness, your lordship, but did not support this case.
Okay. Yes.
Now, your lordship, on basing on PW9 who conducted the raid and PW8 who, PW7 who was the then executive magistrate who contradicted his own statement. Basing on their own statement, basing on their statement, the learned council.
Who all are the members of raiding party? Who the other people?
Party.
3.
PW3 and 4 are the police officers.
Let us see 3. What he says.
Yes, your lordship.
When does he say 3 doesn't say about the timing?
Lordship, page number 36.
Yes.
Page number 36, Your Lordship.
What does he say the timing?
We reached there at about 6 a.m. Lordship, the fourth line.
Okay, we reached there about
We
6
reached
p.m.
up at about 6 a.m. in the village, conducted the raid in the house of the accused Nandakishore Das. The excise
Identified the house and-
identified the house of the accused,
Presence of who?
and then raid was conducted.
This is
In
the-
the presence of some villages of the accused,
Very
the
good.
excise staff entered inside the house of the accused. They recovered 4 bags containing ganja from the house of the accused. They also seized the cash of rupees 1,22,000.
Okay.
And
Next,
one-
next, come to PW4 now.
PW4, Your Lordship.
What time he says?
Your Lordship, if you kindly see, PW4 has mentioned one.
Along with the
important
staff of village, number so and so. Along with the executive magistrate, he says executive magistrate.
thing.
And independent witnesses conducted the house of such so and so.
Yes, Your Lordship. But 81 kg of ganja.
Then if this PW3 is to be believed, the raid has taken place at 6 a.m. 6, then by that time the executive magistrate was already there.
But in the cross examination, you come to the next page, Your Lordship. 30.
No, see, PW7 says at 4:30 he was there.
4:30.
And raid has taken place at 5:30.
5:32.
And see, 5:30 or 6, it is half an hour here and there, that's not an issue. And the PW3 says that it's 6 o'clock. Then how it is mismatching? PW3 corroborates with PW7.
No, but Your Lordship,
You
SI
read
of-
the evidence in entirety.
Your Lordship, the SI of excise has mentioned that the timing is 1:30. The raid was conducted.
1:30 he received the information.
1:30, Your Lordship, come to.
Come to PW9. What does he say? He received the information at 1:30. Yes.
Information that the accused Nandakishore Das was selling ganja in his house on December.
When the raid taken place, what does he say? What time? Does he say anything about raid timing?
The timing of
Check it up.
But Your Lordship, you see, the date is mentioned is on 27. And according to the PW7 and PW4, they got the order on 6/7/1994, on 26th, Your Lordship. So
He received on 26th.
this is on.
No,
20
1 p.m.
This is 27, Your Lordship.
27th, 1 p.m.
27.
He doesn't say anywhere what time they.
Your Lordship, according to
Yes.
to 9 on 27, after receiving the information at 1 p.m, then soon after they proceeded towards the house and conducted the raid according to prosecution 9, Your Lordship. But as far as prosecution 7 and prosecution 4 is concerned,
On
those
27, 6 a.m. they have done it.
27, no, sir, Your Lordship, 26, they got the information, they got the order, and the morning, next day morning,
Come to 3. PW3. Where does he say? Where does he say? 26 or 27?
Here it is 27, Your Lordship, and PW, sorry, PW,
All of them are saying 27.
7 also says nothing.
on cross-examination of PW, let me just speak.
PW?
On cross-examination of PW7, who is we then excited.
Read which part? Which part?
Point number 2, your lordship.
Para 2.
Yes, sir.
Yes, read it.
I got the order on 26/7 to accompany the APR.
No,
force.
sorry. You are very cross examination. Okay.
Yes, sir.
Para,
First para, your lordship. Cross examination, first para.
I have prepared the CD.
No, your lordship. Cross examination, point number 2, page number 44.
44.
Yes, sir.
44. Yes, 44. Yes. I got the order from
26.
26. Okay.
26 to accompany APR force. We left Hon'Ble early in the morning, about 4:40 a.m. The raid was conducted 5:30 and the raid was completed at 8 a.m. Your lordship.
Hmm.
So if your lordship, if you see my only point, your lordship,
Yes.
kindly take.
Yes, dates that if para PW7 says 26. And the other witnesses say 27.
Even
And the
if-
timing is also different.
Even if your lordship, the date are same,
Hmm.
how can XI of exercise who has conducted the raid of his own is telling that he's got the information at 1 a.m. Sorry, 1
1
p.m.
PM.
Sorry, your 1 p.m. And soon after they proceeded with the search.
Hmm.
Now, these 3 prosecution witnesses are differing in terms of timing, that the raid was conducted from morning, like 5:30 to 8 a.m. That shall be taken into consideration, your lordship.
Yes. I got it. Next point.
Your lordship, coming to the third point, your lordship.
Hmm.
There is a non-compliance
Come to the non-compliance part. Yes.
of
42.
42-2.
42-2.
42-2, and your lordship come to page number 50 of the deposition, PW9.
PW9.
Yes, page number 50.
50. Yes. Yes. 28th had submitted the written report.
Your lordship.
On 28th.
Says 42 who says where an officer takes down any information in writing under subsection 1 or record downs for his belief under the provision thereto, he shall forthwith send a copy there to the immediate official superior, your lordship.
Yes.
Now, your lordship, in the cross examination of PW9,
Yes. Yes, which para?
yes, your lordship, I'm coming to that. Your lordship, point number 5.
Yes.
Page 50, the last para. I have prepared the CD at the spot. The statement of the witnesses recorded are not in my hand, but I had given
I read it.
one of the
On
subordinates.
28/7 it was sent. I
Yes,
read that. Yes.
yes, your lordship.
Yes, next 50.
Now, your lordship, coming to 50.
Hmm.
50, it says, the condition under which the search of the person shall be conducted.
Yes.
Should I go through the?
No, it's not required. Yes.
Your lordship, come to 7 para 7.
Para 7 of
Para 7 of page 51, your lordship.
51. Yes.
I have not noted the total numbers of rooms in the residential house of the accused. I have prepared the spot map, but I had not indicated the rooms in the residential house of the accused person that I searched. I cannot say who or others are
Inmates of the
inmates
family
that family
and their
the
relationship with the accused
accused
person. On that day, I had not seen any other. I don't remember to accept.
Except the accused person. I handed over the monogram seal to one of the person in the gathering. Now, I could not remember the name of that person. Again, says I had given to one Chaitanya Naik, who is BW8, who is cited as a Caesar witness. But your lordship, the BW8 did not support this case.
This is PW8.
Yes.
Chaitanya is PW8.
Yes, your lordship.
PW8, not supported. Yes.
After the Caesar had not handed over, your lordship, come to page, paragraph 8, third line, fourth line.
Hmm.
After the Caesar, I had not handed over the seized article to OIC of Jharpada PS for the safe custody.
Hmm.
Your lordship, this comes under section 55.
Yes.
Of,
Safe custody is very important.
the mandatory provisions.
Yes.
After the Caesar, I had kept the seized article, including the sample, in the excise malkhana.
That ungold and that are my
At the
custody.
At the custody till it was produced for the SDJM ungold on 28/7/90.
Next day. Directed produce this.
Should I proceed with the-
report? Then Gunner on the receipt of the directions you done. Yes. Yes, I will. Yes. 55 is not complied according to you. Huh?
55 is not complied, your lordship. Now your lordship come to para 9. The sample packet were not opened before the special judge, nor it was resealed before sending the sample for chemical examination.
There is 9, huh?
9, your lordship.
Yes.
We had not collected the covering of the seized material from the laboratory.
1 minute. The sample packets were not opened before the special judge, nor was resealed before sending the same to the chemical examination. We have not collected the. It is not reopened, then where is the question of resealing? It's not whether given monogram sealed by Chaitanya, I have got.
Your lordship.
It was not reopened. So there is no question of resealing. The magistrate has not seen it then.
Yes, your lordship.
Yes.
And your lordship, come to the last second last paragraph 9, your lordship. I have not mentioned in the CD the reason for not intimating my superior before conducting the search and seize under 421 of the NDPS Act.
Where is that?
Paragraph 9, paragraph 9, third line, fourth line, your lordship.
Yes.
I have not mentioned in the CD the reason for not intimating the
Superior before conducting the search. Yes. 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 Judgment. What judgment you asked me?
One judgment of
Satyanarayan Babu.
Honorable this court, your lordship.
Which paragraph?
Paragraph 8. and
Regarding
11.
regarding 55.
Regarding 52, 2 and 55.
Yes. What does it say?
Your lordship, paragraph 8. Page number 7.
Yes.
A bare reading of the provision would show that the officer authorized to do so is entitled to search, seize and arrest without warrant any person by entering into the building between sunrise and sunset after taking down the same in writing. Subsection 2 provides that such information in writing should be forthwith sent to the immediate superior officer. And here in this case, your lordship, the officer in charge has not intimate the information to the superior officer immediately.
Which is reflecting in para 9 of
Para 9.
para 9 of cross examination.
Examination.
Para 9. Para 9 of cross examination. Para 9 cross. PW9, huh?
Yes.
PW9. Okay. Yes, next. 55. Just come to 55.
55, your lordship, paragraph 10, your lordship.
What does it say? Not clear cut evidence regarding the
Yes, your lordship.
proper sealing
Article at the spot.
Article at the spot. On the
Contrary
contrary,
to
there is
their
clear
claim,
evidence that
the
the article
article
was seized in the police station after the occurrence and this triggered so and so. The reference to the evidence. Not seen earlier.
Your Lordship, para 11,
Hmm.
8th line.
Yes, read it.
Should I?
Yes, yes.
A person cannot be convicted of an offense unless the prosecution comes forward with evidence is readily acceptable and credible. So, Your Lordship, in this case, my submission would be of 3 points, Your Lordship. The first is there is a discrepancies of timing. The second is there is the prosecution.
42.2 is not complied, 55 is not complied. That's your submission.
Yes, Your Lordship.
These are the 3 basic submissions. And insofar as 42 is concerned, you have relied upon para 9 of the cross-examination PW9 and 55, about 55, what do you say? 55 you see whether it is sealed or not because it was not open before the magistrate, or the whether it was sealed or not, the only witness was PW8 who has turned outside. Yes.
And you have lost the case number 47 of
47? Yes. Hmm. Yes. Yes. Yes, yes.
I noted down that this is on my behalf, on my belief, and without affording any opportunity for escaping the accused and concealment of the evidence, I immediately announced Mr. Petroleum Party proceed to the house of the accused.
Hmm.
So as because there was no time for obtaining search warrant and C was not obtained, as because there was no time for me to intimate my senior superior, as I was also in charge with the inspector, there was no necessary for me to comply such warrant. Okay. After reaching the spot, we guarded the house of the accused. There I found the accused Nandari Shodas and Subhash Chakratas who are present in their house.
Yes.
And
But
my-
what is the timing? The merely saying that I don't have time. I didn't have time. What is the timing? Hmm. Then this part is the completely blatant untrue statement. I don't have time. You will see in almost all the cases, IO statement, this part, this line you will get. I got the information, I had no time, so therefore I proceeded. But that has to be cross-checked whether time was in fact there or not. There was time was there or not. In this case, it appears there was enough time. He could have complied with 42.2. In almost all the NDPS cases, IO evidence you will find this sentence would be there. Now Mr. Ragada will tell. I had no time. I got the information, I had no time, so therefore I went. This will be the standard statement of all the IOs. Only to avoid 42.2, they say this. But at the same time, you have to see in the record whether time was there or not. What prevented him from complying the procedure? Here what he says is the time, there is a lot of discrepancy in time. Even if I believe your time to be correct, then he had enough time for complying 42.2.
Your Lordship, another point I would like to place, Your Lordship. If you see PW7 in his cross-examination has said that he got the information on 26th. Now PW9 is saying that he got the information at 1
That's
PM.
the whole
27.
difficulty. That's the whole
That
difficulty.
discrepancy
So therefore,
should be taken into consideration. Your
therefore,
Lordship.
let us take it 27 also, 1 PM, 27. 1 PM he got. He could have, and in the same time he says that the magistrate was there, I took, but 42.2 I will not comply. What is this? He had time to go to magistrate's house and bring everything, but he will not tell it to the superior officer. That's the whole difficulty. These in NDPS cases, copy paste FIR, copy paste charge sheet, copy paste statement. Only the number and everything is changed. You take out any FIR, you will find that. Take out any charge sheet, you will get that. Now in the computerized thing, and it is easier for the police officer to file a charge sheet. Exact same thing, they'll take it, change little bit and file it. Yeah, that's the problem. How will you explain time, madam? That part is enough to record a acquittal.
Yeah.
Then one is enough, not necessary. The
But
timing
prosecution has
is
to
directly
prove
conflicting. Your all the statement, the strongest witness would have been the magistrate who accompanied. He says that 26th I got information. By the time I went, everything was over. That's what his evidence is. Okay. File written note if you want to file. Okay. Reserve. Yes. Yes. Next.
18.
Yes.
Well, the appellants have been convicted on section
File.
P1.
Yes. Yes, sir. Offense.
P1B of the Scheduled Caste and Scheduled Tribes Prevention of Atrocities.
31D.
Yes, boss. 31B.
Even D for the Lee. Victory. Okay, V. Okay.
The act has been amended, plus earlier.
Mhm.
You can see this P1B like this.
Yes.
Yes, my humble submission, lordship is, and I said 31B, no charge has been framed.
31D, na?
Yes, boss. And charge has been framed, laws under section T1X. That you will also get at page 23.
Yes. Charge is framed at 31X.
31X.
1.
And I have not been found guilty.
Not found guilty.
Yes, you have.
Let us see.
Yes.
31.
31X.
Which page?
Page 23, charge.
23 charge. Let us see. 23 charge.
And they were committed an offense punishable under section
31X.
31X.
X. Charge framed.
You'll also can see 31X from the act itself, what it says.
31X. Okay.
Intentionally, whoever, that start from
Yes.
the punishment for offenses of atrocities, whoever not being a member of a scheduled caste or scheduled tribe, X intentionally insults or intimidates with intent to humiliate a member of a scheduled caste or scheduled
You are
tribe.
reading the new one or old? The one which you have given me?
Old one, this is the old
The
one.
one which you have given me.
Yes.
But X is deploy special police.
Somebody belonging to scheduled caste and scheduled tribe must have been humiliated in public view. That intentionally insults or intimidates. You also has got it, plus 31X.
P1X. Rules देखो.
Fast.
Yes,
Oh,
yes, I'm so sorry.
Mark करती हूँ more.
Yes, I'm so sorry. Yes, I got it.
Yes.
Yes.
31X.
Intentionally insult,
Insults
intimidates
intimidates
with intent to humiliate
a member
of scheduled so and so.
in
Any
any place
place
within
within the
public
public
view.
view.
Within public view.
Yes.
So no charge in framed so far as section 31B is concerned. For a moment, also can see what section 31B
Wrongfully disposes.
wrongfully disposes
Huh.
a member of a scheduled caste or a scheduled tribe
And-
from his land or premises or interferes with the enjoyment or his right over any land, premises or
Altogether
water.
diagonal different.
Yes, plus.
things.
Yes. So specific charge should have been framed there. So no charge has been framed. And
And
you
you are
lost my,
convicted under that section.
and you lost my kindly find. You will find from the judgment itself that is page 13. You lost my page
13,
13.
Yes.
Page 13 was
Para 7.
paragraph 7 was just to prove fifth line. Therefore, the utterances.
Hmm.
The
Therefore,
utterances issued
therefore,
by the accused persons,
utterances-
as differently stated by Title 1 and 2, would not make them liable for any offence whatsoever under section 3(1)(x) of the SC/ST and Prevention of Atrocities Act. So charge goes.
Charge goes.
Just sorry, how to say.
Hmm.
I'll come to page 15.
Yes.
I'm starting from page 14, paragraph 9.
Yes.
The incident took place on 3/11/1993, but the complaint petition was filed on 10/11/1993 in the court of the STGM Baleshwar, wrongly, of course. Information was lodged at the police station, but no action was taken on the report of the complainant by the OIC of the concerned PS. Due to poverty and ignorance, perhaps,
Perhaps.
the complainant was unable to call for the FIR lodged before the police to be proved in this case. He could not bring the inaction of the police officers to the notice of his higher authorities, believing that his grievances could be redressed in the proper forum, that is, the special court, where he took shelter later. The defense, it is important, the defense could not examine any witness to prove that the disputed land belonged to the accused persons. If there is no charge loss, or the question of proving by the defense, prosecution should stand on his own leg, not on the lame leg of the defense.
No, let us see 313 whether these things were put to him or not. Where is the question? He should know.
Yes, 313 ne kichhi pachra hai.
Then where is the occasion? He should know what are the evidence.
Yes.
Because whatever the charge was framed on that direction, the evidence is laid. It was not put to the witness, put to the accused in 313. Then where is the question of he leading the evidence in a charge which is not at all framed? Where is 313? Let us see. 313.
6 months at the minute. Two judgments I am citing, and also can see the first one. Dr. Nallappa Reddy, Sridhar Reddy, regarding addition of, there is no addition of charge in this case. So what is the requirement?
Just let us see 313. What kind of evidence were put to you?
Yes. Yes, madam. Some question similar for all accused persons. Peter 1 Jogendras and Peter Panchanan Murmu have stated that once 3 years back at about 10 AM, Peter 2 was plowing his land. You came and abused him. Plus language Santana to kahin ke amma jamiri halo.
But I have stated that you have found with the last time and love coming out. Dispossessed,
Yes.
basically. The evidence is
Specific question should have been, it is your land. He should have proved it is my land. And the complainant himself is a complaint case. The complainant
only 3 questions.
Yes. Yes, please. Yes.
313.
Yes. That is.
Kind of. Yes.
2 judgments plus so far as Dr. Nallappa Reddy, 2012 SCC 467, paragraph 15 and 16. Purpose of partition, paragraph 15 and 16.
15 and 16.
Our judgment at 2021
Please read it. Paragraph 15
and 16. Where is the power of the court to
alter the charge?
Yes, additional. That has not been done here in this case.
Section 216 APS that to the provisions of section 216. The court is authorized to alter to charges on any time. Whenever such a alteration What was the charge in this case?
Charge plus?
In this case?
31X.
No, in Nallappa Reddy.
Nallappa Reddy?
406-420.
Yes, plus. That's the principle on 216 plus.
Yes.
The next judgment, Sujit Vishwa State, that is the principal on section 313 of CRPC.
Para?
Para 2021.
Para 20 and
21.
21. Yes.
Now the requirement of section 313.
See, the incriminating materials is not placed, put to 300,
Yes.
the
Nothing-
and everything goes. In this case, there is no material insofar as whether
That
the
land
belongs to them or
Yes,
not.
yes. Please. Great. Please. Okay, lamp evidence देखो ना evidence नहीं PW evidence किसी कोई लोग
Exhibited, then more of a reason it should be put to the.
तापर चार्ज ही नहीं
The land. Complaint.
Okay.
And also my lawsuit can have belongs to page number 4.
40.
Yes. The judge.
40. 14, yes.
Paragraph 1. The incident took place on 3/11/93, but the complainant petition was filed on 10/11/93 in the court of SDGM Mysore. Wrongly, information was lost at the police station, but no action was taken on the report of the complainant by the OIC of the concerned police station. Due to the property and ignorance, perhaps the complainant was able to call the FIR or.
The hypothetical analysis of the land and trial court.
Read it.
Because the police proved his case, he could not bring the inaction of the police officer to the notice of his higher authority, believing that his details could be replaced in the process court. That is the special court, where he took the center line. The defense could not examine any witness to prove that the dispute land belonged to the accused person. Duly consider the evidence of the person.
First of all, they have to prove that this land belongs to them. And it has to be put to him. Thereafter, there is a question of defense evidence.
Stemming himself as PW2, the complainant has stated that he has 0.6 decimal of the agricultural land which lies at the end of his village. This land is covered under the cup number 501 and plot number 164, which he has not sold to the accused person. The location of the case land was corroborated by PW1 and it lies at the end of the village. The overcast done by the accused person as supposed to by PW2 where that he was found in his land. The accused person, Gangadhar, Gagan and Ranjan came to his land. They abused him.
Yes.
The words uttered by the accused person in the form as a PW2 has stated that different from the PW1.
That is not believed. Abuse part is not believed. See, the requirement is, first of all, you have to prove on record in order to bring home the charge of 3xB. Okay, sorry, 31V. That the land belongs to the complainant, the victims. And in that land, these people were trying to dispose them. These are the three elements. One, first is land belongs to them. And these people came and trying to throw them out. This is the requirement. But in this case, what had happened is nothing is proved. Rather, the court says that the land belongs to them or they have to prove in defense. How will they prove? You have to prove your case first of all. You are not able to prove his case, and they say that since they have not proved, so therefore I will convict. What is this? This is against the fundamental principle of law.
Prosecutor should not stand on the lame like a defense.
You have to prove the case beyond all reasonable doubt. Onus is on you to prove. But the trial court says that no, they have not proved by bringing defense evidence. Even if I will accept that action, how will they bring the evidence? They will bring the evidence if the incriminating evidences are put to them under 313. Then you ask, this is the evidence. What do you want to say? Then they will say, yes, I will lead the evidence. That incriminating evidence is not put to them. Where is the question of defense evidence then? This is against the very fundamental principle. Forget about the altering of charge, whatever. This is completely perverse finding. I will retain it for some time. I'll give it back.
Yes.
Okay.
For that reason, I have brought that book.
Yes.
For
Yes.
Yes, item 57 on Tuesday. I am in the midst of a proceeding in court note 5. Was just I'm joining.
Okay, it's all right.
Keep going.
57 rupees. It's good. Take it up. Yes. Yes, it's here. Yes. Yes. Next.
21.
May I please, my lord?
Yes.
There are two appellants. One of them
Yes.
died during pendency of this appeal. It is already on record, my lords.
Yeah.
That order dated 39.
We are 57. Which item?
21.
Yes.
The conviction under section for the appellant one, it is 304 part 2, 324, 323 and 34 IPC.
Yes.
For 304 part 2, it is RI for 3 years, 5,000 fine with default 3 months RI. 324, it is 2 years with fine 2,000. And for 323 and 34, it is RI for 6 months. Initially, they were charged under section 302, 324 and
302 converted to 304
4
part 2. Yeah.
And 323, 34. My lord, the
One of them has died, huh? Charges were framed, my lord, under section 492-304B, along with the 4 DP Act, my lord. He is convicted for 492 and 4 DP Act, my lord. Acquitted from the sentence of 304B. Yes. Under conviction under 492 and 4 DP Act, my lord. 6 months. Yes. All
6 months.
total,
6 months, huh?
yes, madam. 6 concurrently. All total 5 witnesses, my lord. PW1 is the informant. PW2 is the priest. Also the mediator. Didn't say anything. PW3 is hostile. PW4 is the doctor. PW5 is the IO who filed the charge sheet. IO has not been examined, my lord.
Doctor, what does the doctor say? PW4 is doctor, huh?
Doctor, my lord. It's saying about the 15-1 in
Damayanti Naik,
yes,
the deceased.
yes, my lord.
How she died?
Poisoning.
Death was probably due to oleander poisoning. But before this,
Regarding the dowry torture, nothing has been whispered, my lord, either before her death or during that marriage time, my lord. Marriage is of
PWD hostile, what he says,
PW3.
he,
hostel,
the
what
sister of the unbelievable dad, she committed suicide taking poison 2 to 3 months prior to her death. There was.
Where are you reading, madam?
PW3, my lord.
As
Para 1.
2 to 3 months prior to her death, there was a quarrel in their house.
There was some quarrel.
Quarrel, my lord.
With Nityananda and Uncle of the Damayanti sent me information for a village Mishra, but I did not go there. I do not know anything other.
Yes. That Nityananda has not been examined. And also the informant is saying nothing about this matter. Rather, he is supporting matter. Page 22.
Well, let us see the informant.
Informant, PW1, my lord.
One.
What kind of evidence? There is no evidence at all.
Yes. He is saying, out of anger, I filed register the affair. And
IO is not examined. Only one witness is not supporting. The all other witness, 2, 3 witnesses, 1 line examination.
The torture marks in.
Read only then PW1 is the only
yes,
witness.
I am reading my
the read it full.
Full, yes, ma'am.
If anything, tell me.
I am the informant. Damayanti is my sister. I gave Damayanti in marriage with the accused in July 91. At the time of marriage, I paid rupees 5,000 to the father of the accused, and the rest 5,000 was promised to be paid later on. There is no demand of dowry, my lord. But as the same was not paid, the accused and his father attributed immoral character to my sister, and that is terminated her blamed her pregnancy as an illicit pregnancy. But my child is with me, my lord. Right.
Okay, my sister.
Yes.
Read it. My sister.
My sister was also beaten and injured. On 15/1/94, I heard that she committed suicide eating poison. So I reported the matter to the police orally, and the SI reduced the same into writing. The contents of the writing were read over and explained to me, and I signed the same, having found it correct. Exhibit 1 is
Who
the
is the
FIR.
scribe of FIR?
He is saying I filed my.
It was filed, but who has written it?
Nothing written, madam. The page 18 is the FIR. Ketanand Malik signed.
Scribe not examined.
Not married. Cross examination then, madam. The cash was paid on demand. Other things were gave out of my sweet will. I myself gave her in marriage.
The cash was paid on demand.
Demand.
Yes.
Other things were given out of my sweet will. I myself gave her in marriage. Kruttibasa was the mediator married. PW2. The marriage
PW2.
2. He is saying nothing.
Yes.
The marriage talks were held at Mangalpur about 15 days before marriage, and it was settled then. 2 to 3 persons from their side and 2 to 3 persons from our side were present. The terms of dowry demand were not reduced into writing. Out of anger, I made the affair. Damayanti gave birth to a son who is now staying with the accused. I was examined by the police on the date of affair. On 2 occasions, I visited Damayanti in her in-laws' house, but on these 2 occasions, I was received with all cordially. Damayanti read up to class 7. She was capable of writing letters. She also came to my house 6 to 7 times. I used to return her. It is not a fact that Damayanti committed suicide, but not for torture.
Yes,
on
this is
staff.
1. 2 is one line statement. 3 has not supported the prosecution. 4 is, who is 4?
Doctor.
4 is the
I
doctor.
only filed charge sheet matter.
And 5 is I filed the charge.
Only filed charge sheet matter.
Yes, madam.
PW
Except PW1.
Yes.
What else you have?
After revision of the doctor, in the PW4.
That is not believed by the court. Poisoning. Poisoning is there.
Poisoning before page 26.
Yes.
The red color about the scapular region, pattern Brucian stick, 3 into 1 inch with swelling with substantious increase of blood sample and antemortem.
Mm.
Red color pattern bruise of stick 3 to 1 inch with swelling of superannuous infiltration of blood.
Contusion.
Simple and antemortem.
Contusion, right.
Middle ring and finger of right hand, 2 into 1 centimeter each, simple antemortem.
And in his cross, he is saying
The death was probably due to
coriander, coriander
Coriander
coriander poisoning.
Yes.
Main case में तो
How the trial court deals with it? Let us.
sorry madam. Trial process.
I prepared a slip and noted the findings.
My relevant portion page 9 para 5.
Income usually was there on the person of the deceased.
Yes. Yes.
Even that priest malady is saying nothing in about the demand of dowry in his 161 statement, madam.
No, trial court, how trial
Yes.
court is?
Page 9, paragraph 5, madam.
Para 5.
Yes.
And there. Yes.
Prosecution has examined 5 PWs in order to prove the charge against the accused, including the medical officer and investigation officer. But the real IO, Sri S.C. Ghosh, has not been examined, and no explanation has been offered for his non-examination. PW1 Kedarnath Malik is the informant who has supported the FIR study. PW2 Kruttibas Das solemnized the marriage as priest, but he has no knowledge about the dowry demand and subsequent torture for non-fulfillment of dowry matter. PW3 is the witness, he all turned hostile. And coming to the evidence of prosecution test in detail, I want to. Then page 11.
Yes. the second line, man, the evidence of PW1 is cryptic, though he made an affair.
At the top, huh?
Yes, madam.
The evidence of PW1 is
It's
cryptic.
cryptic, though he made an affair.
Ah.
Perhaps for some extraneous reason, he is unable to support the prosecution story with a view to obliging the accused. Experience shows that in a quite large number of cases, unscrupulous and greedy parents of a victim settle the matter with the accused out of court for gratification and later on become hostile to the prosecution or depose unreliable evidence so as to secure an order of acquittal in favor of the accused. But there is no remedy against such malady. Whatever be it may be, a man may lie, but circumstance will not lie.
What are the circumstances, madam?
11, page 11, last part.
Marriage is the only circumstances. No, what circumstances you have?
11, para last para.
And the finding is PW1, the only witness which you have examined. The finding of the trial court is he has made a cryptic statement. It doesn't support the prosecution. But he might have been won over by the accused.
This is that judgment is saying.
The page 11.
Yes.
As regards torture for non-fulfillment of dowry demand, there is no evidence but the facts remain.
Where are you reading?
Government
As
was
regards the
victim-
torture.
That man.
That the government was victim before death, leaving marks, violence on her body, as it evident from the medical evidence.
This is also settled position now. You have to, for 498, you have to be specific. Yes. Merely saying that physical mental torture doesn't mean that 498. Unless you specify what kind of torture, when happened, what happened, all these things. General statement, on the basis of general statement, one cannot be convicted.
All these things could have been stated by the IO, but he has not been examined. I am relying on a decision, my lord, of Honorable High Court of Calcutta, my lord.
Where is the show me 313. This incriminating evidence was put to you.
313.
No, 313 statement.
It's my lord, page 19 and page 20, my lord. Page 20. 4 and 5, my lord. It further transpires that Damayanti committed suicide having been unable to withstand the torture. What do you say? Se atmahatya korichi matra ama dosara nuhe. Then what more you want to say? Bhaktaragu rakhya paya pai atmahatya korichi.
Madam, come to the finding now. Para 12, in between. What is the basis of the conviction is this. In the present case, read in between. In the present case, no explanation has been offered. Read it. As to
Page 12.
as to this about 12, page 12. As to the
Sixth line.
circumstances
Hmm.
under which the mark of violence, such as red color contusion and over the sculpture of regions of contusion in the middle ring and finger of the right hand side of the disease occurred.
No explanation.
When he will give explanation, if this was the incriminating evidence, have you put it in 313? This part of the evidence, have you put it to him? Then how would you say that he will explain? In 313, what it was put? Just see, page 19, come to page 19. This part of the evidence, which was now read against him, was not put to him. So how the explanation will come? You say no explanation has come. Explanation will come if you put it under 313. That was the basis of conviction. Then thereafter it writes, the accused is bound to give explanation for the same in view of the section 105 of Evidence Act. You have not proved the case, he is bound to give. And in the absence of explanation, as the presumption can be drawn, the accused is beaten the deceased accused severe violence and in the body, and which has driven the woman to commit suicide. The evidence of PW1 is the immoral character and so on, so you all these things. So this part of the evidence is not put to the accused under 313. So therefore you can't read it. And you can't say that the explanation is not given. He could have given the explanation if it would have been put to him. You would not put it to the accused. Anything else you want to say? How many accused are there?
Only one, my lord.
Husband.
Accuser 4, my lord. FIR was registered as 4, my lord.
All of them are accused,
Yes.
acquitted.
Yes.
Yes. Okay. Like to say anything? Is there any material? Judgment is available.
Obliged.
Thank you. कितना ना? हाँ? Because 52. Mr. Ragada, you are waiting for which matter?
63 and 94. 94 take 1 minute. 63.
So, see, whichever takes 1 minute only I can do it. Because 94.
63 may learn, senior is 18. 63 BP is not with me also, only.
No, 93 is the
94.
94. Let us see the 94.
Yes, madam. 4 actors face the trial, madam. Section 392 and section 45 of Arms Act, madam. 4 madam, the against 4 madam cases split up. Against 4 actors place split up and 4 face the trial before sessions court. And 4 of them are acquitted. One of the acquitted accused came forward and filed a petition for 52 that my vehicle motorcycle may be released in his favor. The court and the trial court held that since there are other 4 accused persons yet to be held the trial, at this stage I am not.
What happened to their trial?
For that, this must have been 2007. Other rest 4 accused persons must have been held the trial. So release of vehicle, the cases are pending since 2007.
Only for release of vehicle.
Answer 3. Motorcycle.
What will you do with that motorcycle now? 2000, when incident taken place when?
Taken on 16. And the case of the year 2006, madam.
2006.
Yes. And the 2007 man for release of the motorcycle. The trial court rejected on the ground that 4 accurate to be has the trial. Since case split up against it.
It could have been released, interim release also you could have done.
Question not arranged, madam. As because 4 of them have to face the trial.
Seize from whom?
Seize from the petitioner. But in fact, vehicle recorded this case. And now the vehicle holder is existent on that is doubtful.
Shall I get a report?
report matter, the report authorized matter scope will be given to the petitioner to move affairs if the four acting persons acted or had the trial. It will better matter.
That's a better
He
idea.
asked not for the application after the He asked you in every.
I'll give, I'll dismiss it with the liberty to the move application.
Yes.
Right on.
Confirm the matter,
Right on.
order of the, confirm the order of transport.
No, this order is passed by Sessions Court.
Additional session judge, fast track for that. But the split of right pending before the JMFC for that.
Okay. Then there are four, how many accused?
8 acting persons, that are reflected manner in the
Eight accused persons.
second page of the order manner.
Second page of the order. Let me see. Okay.
For the split of the trial against the other acting person, it may be mentioned here that all this total, there are 8 acting persons. When the trial has only been concluded in the respect of 4 acting persons, including the petitioner. In the circumstance in view of the pendency of the split of trial, this application for to share should not
And
Not matter.
the appellant has sailed the order dated 5/4/2007 passed by learned additional sessions judge bracket FTC Khurda in ST case number 40/106 of 2006, whereby his application under section 452 CRPC for release of release of what vehicle is this?
motorcycle.
Motorcycle.
Release of
Hero Honda.
motorcycle.
Hero Honda
We-
Glamour motorcycle.
Hero Honda Glamour motorcycle.
Bearing registration number
Bearing the OR dash
02 SG.
oblique AG
2817.
2817 has been rejected. The trial court rejected next problem. It appears that the 8 accused persons were charge sheeted. Since charge sheeted in the charge sheeted in the what is the
for second page the order matter.
offense?
Upper 399 and 402.
Charge sheeted in relation to the
99 402.
Begunia PS case number 51 of 2006 under section 399/402 IPC reduced section 25 and 27 arms act. 4 accused persons faced the trial and the four accused persons faced the trial, whereas the remaining 4 being absconded, their trial got splitted up. The 4 accused person, including the present appellant, have been acquitted by the trial court by its judgment dated.
Judgment they have not mentioned matter. But in fact, matter they have stated only stated that they have acted.
By the judgment dated 17/7/2007, 17/7/2007, passed by the ad hoc additional sessions judge Khurda. Khurda. Okay. Repetition of this please first others were recruited by the said for specifically regarding the school law. In the acquittal order, in so far as the release of vehicle is concerned, the trial court observed that no order could be passed regarding the disposal of the seized property in view of the pendency of split of trial. Also, against the said observation, the petitioner approached this court by filing criminal revision petition number 326 of 2007, and which was subsequently withdrawn by the petitioner. After withdrawing the application, After withdrawing the revision petition, petitioner moved an application under section 452 CRPC before the trial court, before the trial court, and which which has been rejected by the impugn order dated by the impugn order, agreed by the said impugn order. The appellant has approached this court by filing the result appeal. Mr. Ragada, on the request of the court, has appeared as amicus curiae and rendered effective assistance. At the outset, Mr. Ragada submits that the fate of the split of trial is not known to him. And he also submits that the incident relate back to 2006.
Yes, sir,
2006. And the seizure has also been taken place in 2006. Much time has been lapsed in between. Hence, it would be appropriate for the petitioner, appellant, to move a fresh application before the trial court under section 452 CRPC, which could be decided taking into consideration the changing circumstances, including taking into consideration the fate of the split up trial. In view of the district council also appears, and he also agrees to the submission made by Mr. Ragada. In view of the taking into consideration the submission of both the parties, I'm inclined to allow the partly allow the petition by setting aside the order dated 5/4/2007 and 4/2007 passed by the ad hoc additional sessions of the FTS Khurda, and granting liberty to the petitioner to move a fresh application under section 452 CRPC. Such application is moved, same shall be considered on its merit, taking into consideration the changing circumstances, and on the basis of the changing circumstances, with the said observation, the petition, the appeal is partly allowed.
Yeah, how he will get the copy, my lord? How he will get the copy? He did not know.
Copy of this order be communicated to the trial court forthwith, and the trial court shall issue a notice to the petitioner apprising regarding the order passed by this court. He might not be having any interest.
So we have admitted
For the yes. It's kind of formal disposal. Yes. Yes, Mr. Sharma, you waiting for some matter?
Two items. One, I have been able to obtain instruction, 87. So the police did not get any information on 87. I am in touch with my client, my lord. So I'll do that next year whenever it is before your lordship.
He is alive.
He's alive.
Yes.
But very old, that's a different thing. And so far as 48 is concerned, I am in the process of getting information about him. So
I have a 48. Have I passed any order for
SP information, your lordship.
both the things?
In addition to SP, I am also trying to obtain instruction.
Okay, I'll list it depending upon the.
On the yes. But 87, I have obtained instruction.
To issue. Making it available.
Sir.
Yes, Mr. Mishra, you would tell.
52.
52. A small short matter.
Short matter, that is only three number of witness. If it can be, otherwise not.
You are opposed. Huh?
Item 1.
Item 1, what do you want? Nobody is there, item 1. Got it. I'll take it up Tuesday, Wednesday, yes. Item,
81.
what do you want? All the matter he let just.
My lord, item 81, my lord, I am the counsel in this case. But due to absence of last 2 days, you will also, I'm amicus curiae, my lord. I am the actually the counsel for this case, so item 81.
81.
My lord. But last 2 days I have not appeared due to missed in the list, my lord. So you will also engage an amicus curiae, my lord.
The problem is,
Gyanendra Chandra.
once I request someone, amicus curiae, nobody appears. And he prepares and comes thereafter you appear then.
At that time I was absent, my lord. So I will not verify the list properly, my lord. That I missed the list, but I was the counsel in this matter, my lord. So how more, so will cooperate with me, my lord?
Okay, let it be, let it.
Let it-
You also appear, no problem.
I will.
Who knows?
I will argue this one.
He might have prepared it.
Mallet, item 31. It's a very small matter, Mallet, that the Sambalpur Malkhana case. So Malkhana ଭିତରେ 2 ଜଣ ପଶିଲେ, I am the employee of the court.
Employee of court, wait then. Malkhana is very dangerous. Because of your problem, many accused might have been acquitted. It is a small case, but you have contributed largely for other accused persons.
Tuesday, এটা 31 number.
It will all the matters will be listed, don't worry. All the matters are listed. Okay, thank you.